Hello. The court case that I decided to look at this week was entitled Sallinan versus Upper Lake Union High School. This court case takes place in 2006 uh, in California. The plaintiff, Sallinen, was injured at a football practice in Upper Lake Union High School. While running the ball, he was hit simultaneously on his left side at his left knee and also in the front. The injuries that occurred by the plaintiff were a fractured femur and a torn ACL and torn meniscus in his left knee. Now, at the time of the injury, the coaching staff did not understand the severity of the injury, and so after practice was over, Sallinen was left in the locker room on his own. Still, again, the coaches did not understand the severity of the injuries, and when practice was over, the coaches had left without checking on the plaintiff to make sure that he had a ride home, that he may need to see medical attention, and the coaches left the athlete in the locker room alone. So what the plaintiff had to do was then go to a payphone in order to contact his father to get a ride home. The problem is that the payphone he had to go to was at the front of the gym. And so in the testimony by the plaintiff, he was forced to hop on one leg, his right leg, his good leg, to the payphone at the front of the gym. The issue that happens is while the plaintiff was hopping from the locker room to the front of the gym to reach the payphone, he slips, he feels this pop in his left knee, and he falls to the ground. Now, this obviously brings on more injuries than what was occurred already on the football field, and so the issue was that the plaintiff was suing Upper Lake Union High School for negligence in general supervision and emergency medical response. Now, the high school did not have an emergency medical plan put in place. The coaches, again, had no understanding of what to do, when to call an EMT or a medical professional, or the severity of the injury. Now, the plaintiff, he had multiple surgeries, one occurring in September of 2002, and the second was in March of 2003 to repair the fracture in his femur. There was a surgery in July of 2003 to repair his torn ACL in his left knee. The problem with that surgery in 2003 was that it did not actually heal the tear. It did not repair the tear fully. The meniscus tear in his left knee was ultimately healed on its own, and the orthopedic doctors that worked on both his femur and his tear in the ACL decided that there needed to be more surgery to repair that injury to the ACL in the left knee. The trial that would take place in July of 2006 ultimately resulted in the plaintiff's father testifying that he did not have the money to, of course, pay for the medical bills and was unable to pay for the medical bills of the previous surgeries in September, March, and July of 2002 and 2003. And with the increase of the injury to the ACL and the additional surgeries that were needed, the plaintiff and his father were suing the school district for negligence and the award of paying these medical fees and the damages that were occurring to the plaintiff. Now, Upper Lake Union High School, they decided that it was not the fault of the coaches or the school district in which this injury had occurred, because the injuries occurred on the football field. The school testified that they were not liable because it occurred on the football field under the supervision of the coaches, and there should have been taken measures there, and that the insurance and liability coverage of the school should have covered the plaintiff. The problem came about was, did the injury that occurred after the practice, was that the reason for the extended surgeries? Well, the judge in this court case, it was seeing that the testimonies that were given were in favor of the plaintiff, and in fact there was an award of $250,000 to the plaintiff to help cover those costs for the surgeries that had already occurred and the surgery that was supposed to be scheduled for July of 2006 at the time of the trial. Now, of course, the school had appealed this case, and it went to the California appellate courts in 2008 in order to review the case, and the Upper Lake Union High School filed a appeal on the original verdict of $250,000 being awarded to the plaintiff, in the understanding of the grounds of surprise. Now, this surprise was that one of the eyewitness testimonies in the original trial was not meeting up with the actual facts of the case, or what the original testimony was given at the beginning of this whole process of finding the information out, what has happened to the plaintiff in these injuries. The Court of Appeals for California, they decided that the grounds of surprise and the original testimony was not viable to have a retrial or to overturn the awards given to the plaintiff. And in fact, the California Court of Appeals upheld the award to the plaintiff of $250,000 for the injuries that occurred and the surgeries that ensued. Now, this court case really struck to me because it is more and more that these injuries that occur on the football field or on the practice field or any sporting facility really can be a major problem, not only for the coaches but also for the athletic administrators. Now, of course, under this case, the coaches were seen as showing negligence in general supervision, not asking the plaintiff if he was okay to be able to walk home or be able to find a ride home. They did not ask for the severity of his injuries at the time of their departure from the locker room. They left the plaintiff alone, and even at the time of the injury, the coaching staff did not have that medical plan in place to decide what to do in this time of a medical emergency. There was no plan to decide how to assess the injury, what to do, who to call, where to go, or anything along those lines. And so because of this understanding that both the coaching staff and the school district really had performed negligence and did not perform their duties of general supervision and emergency medical treatment, it really shows that there has to be some type of plan in place, because injuries can occur anytime and on any grounds of the school. So it could be at a practice squad where the soccer team, a student athlete gets hit with a ball in the head and suffers a concussion. Well, the coaching staff, the trainer, the athletic administrator, they all need to have an understanding of what to do in that time. Do they call the parents? Do they contact the EMTs to try and get the help that is needed? It needs to have the severity of the injuries taken into account, and the emergency medical plan needs to be put into place in these instances. And all the coaching staff needs to have an understanding of what to do and where to go or who to call in order to make sure that these issues are taken care of as quickly as possible and as safely as possible. Now, of course, the trial really has set the precedence for many of these negligence issues that have come about with the injuries of student athletes on the practice field in competition, and really shows that the athletic administration and the coaching staff need to have that emergency medical plan in action, so that they can contact who they need to contact, have directions for the EMTs, and have that insurance available if there is an issue that needs to be taken care of. That is why I really like this case, because as a former coach and a future athletic administrator, I know that there needs to have this understanding of protecting the liability of both the school district, the coaching staff, the athletic administrator, and of course protecting those student athletes on all levels. As you know, being a former coach and a former athlete, making certain that these student athletes are taken care of is the number one priority. And that is one way of trying to prevent future lawsuits and other issues that could come up in later injuries to a student athlete in both the practice field or in competition. Thank you very much.